Well, 22 individuals linked to the July 2021 civil unrest are expected back in court later this month. This is after they were granted bail in the Durban Magistrate's court on Friday. The Hawks say more arrests can be expected in the coming weeks as they continue to probe the violence and looting that claimed over 300 lives. Legal analyst Mpumelelo Zikalala joins us now on how we can expect these cases to actually unfold. And Mpumelelo, thank you so much for your time and thank you for joining us this morning. I mean, talk to us about that. This is the scale, I think, of these cases is probably what's top of mind for a lot of South Africans. I mean, can we expect the state to struggle a bit in terms of dealing with that?
Good morning to you and also to your viewers. Yes, we can. We are currently dealing with the legal system, with the court system, which is very stagnant. It takes a number of years before a case is ready for trial. And the more number of accused you have, the longer it takes. But there can cite many other cases that have dealt with what we have today. Then secondly, let's deal with the crime in which has been alleged in this particular case. It's not a very prevalent one, and I do think that they're going to struggle in terms of the collection of the evidence that they are requiring, because at the end of the day, they have to prove their case beyond reasonable doubt when they're in court. And in order to link that, we have then to say, due to the instigation that has been caused by the accused, this is the damages that have been suffered. The people that looted or participated in these riots were instigated by them. There must be a causal connection between the two. If there's none, then their case is very weak, and the accused may end up being free at court when the trial actually starts.
Talking about the gathering of evidence, we know that during this particular period, a lot of these incitement messages were often circulated on social media platforms, such as WhatsApp, for instance. And I think first thing that comes to mind is privacy laws. Is the government allowed to sort of just get access to one's WhatsApp messages in order to build its case? I mean, what role do privacy laws play here at all in an investigation of this nature?
They play a huge role, to such an extent that the only time in which they will start to have access to whatever that has been written within a device which is owned by you is when there's a search warrant that's been issued, and it's been issued by the courts in terms of saying, go and investigate what Zikalala was actually tweeting about or stating in those WhatsApp groups. But in this case, it's a bit different. If you have access to a public platform such as any social media platform, once you have published that particular message saying that let's go and do 1, 2, 3, 4, 5, it is taken as if you have spoken it in a public platform. Anyone or everyone has access to it. And I think that is where they started in terms of the investigation, and they worked their way back in terms of saying who issued these messages. Let's then start and place charges upon them. After we have done that, then we can go and collect that devices and be able to check what sort of communication was being done. However, that doesn't take away the causal link requirement, which is very crucial in this case, because once you get into a criminal matter, a person has to be found guilty beyond reasonable doubt, meaning there must be no other explanation other than the one in which the prosecution is issuing out or submitting to the court that this particular individual is really guilty. So show me the causal connection between the messages that have been sent by these 20 individuals and the riots that have took place. If there's no causal connection, you have a very weak case. That particular individual must be found guilty, which would make this whole exercise of arresting 20 people a brutal one. And from us as members of the public, then we'll come back and say, where is the intelligence? How was these matters investigated? Were our law enforcement officers equipped to do these various investigations? Or was the manner in which this particular process was supposed to be investigated being done differently? For example, look at the real instigators, the ones that are sitting on top, that planned, then orchestrated all these things. And don't look at the small fish in the pond that actually executed the actual looting and all the other activities that took place within that particular phase.
Now, in terms of South African law, Mpumelelo, we know that it's the Riotous Assemblies Act that is the codified law that essentially will be at play in much of these cases. These individuals have been charged with conspiracy to commit public violence as well as incitement of public violence. Are those traditionally difficult cases to prove, especially around issues of intention? I mean, you mentioned the fact that we have masterminds who essentially orchestrated the entire unrest, who are yet to be arrested and yet to be brought to book. What we're dealing with here are, as you've said, sort of low-hanging fruit. How is the state going to prove the intentionality behind the acts of these individuals, or the alleged acts of these individuals?
They are very difficult to prove, even though there's a common law crime of public violence. Then you have the Righteous Assemblies Act, which tries to sort of codify and make it easier for the prosecution by saying that you don't really have to have the intention of saying that the message in which I'm spreading out must be heeded by someone. The mere publishing of that particular message can be considered or taken as if I've done the publication element or part of it, and the only thing that I need is for people to react to the message that I've sent. Now, the courts have been very clear in terms of saying, let's take a reasonable person who is in the position of the looter, for example. Is that particular individual going to accede to a call that has been made on social media, either Twitter or let's say WhatsApp or even Facebook, in order to say, I received a message from Mpumelelo Zikalala on social media saying that I must go and loot my local mall, and this is what I'm doing, and I'm acting on those particular instructions. And that's actually going to be the defense of the 20 individuals that are there, because they will come back and say, show me the specific individuals that acceded or responded to my call, and show that it is not on their own violation or their own sort of processes that they then decided we must go and loot this particular mall. So if there's no causal connection between the two, you can't prove that I'm guilty beyond reasonable doubt. You may have the Righteous Act, which is hopefully going to assist you at some point in time. However, it does not remove the causal connection which is required by our courts in terms of saying, show the causal link between the message that has been published and the person acting within that particular consent scope and in compliance with the message that was issued. If you don't have those, then your chances of success are going to be a bit slim. So unless if the police are going to come back and say, these are the 20 looters that we've got from this particular mall, they are saying that they wouldn't have acted this if they hadn't received the message from this particular instigator, then the chances of success are very slim, which is why I say maybe the police could have approached this particular process differently. First, by saying, let us look at the people that we found with the stolen properties and simply ask them, what caused you to go and loot in the manner in which you've done so? If they agree and are found guilty, only then you come to the instigators. Don't prosecute them simultaneously because you're not going to win. Or, if you have done investigations such well that you've received the devices, it's very easy for them to prove that it was a concerted effort between the 20 instigators, well-planned process of saying that these are the messages that you are going to spread out, and people definitely are going to respond to our call to go and loot, then you are going to be successful. If you don't have those, you are going to have a problem.
Another element here is just the amount of time that has lapsed. Not so long ago we were actually sort of reflecting on the year past since the July unrest. So we are talking about something that happened a little over a year ago. Is that likely to affect the state's ability to prove or to prosecute its case, given how much time has lapsed since the actual riots?
Definitely. Whenever you have a criminal case, the quality and the quantity of the evidence is crucial for both parties, because people, some of them, they die. Evidence is sometimes lost. Evidential material is sometimes lost. In order to be able to prove some of the cases here, you even have to gather the SAP 13s in terms of the things that were looted. If you can't find any of those things, you're going to have a problem. The burden of proof on the state side is that it must be guilty beyond reasonable doubt. The minute there's doubt in terms of the manner in which the investigation took place, there's doubt in terms of how the evidence was stored, there's doubt in terms of the causal connection between the two, definitely you are going to have a problem. So it's going to be a very uphill battle for the state in trying to prove all of this. In addition to that, simple logistics. You have 20 accused in the box, meaning that whenever they go to court in any given stage in time, even if there's 2 accused who are not there or the legal representatives are not there, the matter cannot proceed unless there's an application for separation of trial. Then the question is, how long would it take for the state to complete the prosecution of these particular individuals And by the time that happens, are there any sort of repercussions which are going to take place other than people going to prison? If you can't achieve the low-hanging fruits of getting prosecutions as quickly as possible, you are going to have a problem. A simpler approach would have been, let's hold a much more proper inquiry in terms of saying, let us look at how we as a state are doing our jobs in terms of the intelligence side of things. Are we able to get information quicker? Because we want to prevent a situation of a looting on another stage and make sure that you're able to curb all these instances while they are starting. If you start with this particular process, this is supposed to be done at the end. Maybe they've done so after spending a year dealing with these matters, but I don't think they're going to be successful, taking into account the track record of our law enforcement agencies and the track record of how our courts have handled these type of matters before.
Mpumelelo, thank you so much. We are going to leave it there. That's legal analyst Mpumelelo Zikalala helping us to unpack developments that took place in court on Friday. Of course, that's a story we'll continue to watch as the suspects return later this month.